I'm Lizzie Whittingham and I'm a partner in BLM's Property Damage Department. I've been dealing with transport-related matters since about 2016, and I'm here today with Sue Ruddock, who is the Legal and Insurance Manager at Transport for Wales. Hi, Sue.
Hi, Lizzie. Hi, everyone.
What we're going to be talking about today is a few of the current issues to do with Japanese knotweed and its presence on railway land. Unfortunately, there's a lot of it in Wales, so it's something that Sue and I are often talking about. So a real headache in up till now has been the RICS guidance from 2012, which has been used as a sort of gold standard by mortgage lenders, and it was created at a time when I think people thought Japanese knotweed was much more dangerous to buildings than it is considered now. And the guidance said some rather unhelpful things, such as, do not lend on a building where there's knotweed within a 7-metre radius. So it's quite extreme, and fortunately the botanical experts specialising in invasive species have come to appreciate that it's actually nowhere near as dangerous as once was thought, and that guidance has been withdrawn and replaced with a new draft. Sue, do you want to tell us what you think of the new draft?
Yeah, well, I certainly think that the new draft shows that Japanese knotweed is much less of a threat to buildings. The guidance says that there is no risk to intact concrete. So the Japanese knotweed does tend to take the path of least resistance. So if you do have intact concrete, then it's going to find other ways around. Japanese knotweed more than 3 metres from a boundary also doesn't now need to be reported to a lender, which is good news, because a lot of ours can be, a lot more than that. A lender can still finance a purchase even if Japanese knotweed is close to or present on a property. Although if damage has been caused or amenity affected, then the lender can require that the Japanese knotweed is treated as a condition. So yeah, it's recognised most residential gardens, herbicidal treatment is the most effective and sufficient treatment. But I can return to that again shortly. It makes a big difference. The Court of Appeal in Williams and Wastel obviously established that Japanese knotweed had to actually be present on the land for an owner to be able to make a claim in nuisance. But this guidance takes away much of the fear about Japanese knotweed, and in most cases the property can still benefit then from a mortgage, which is good news for us, good news for the homeowners.
Yes, indeed, good news for everyone. And what we've seen in the past, haven't we, is that diminution in value because a property couldn't be mortgaged or remortgaged had been used to push up the value of a claim, and if that falls away, then the claims are really worth a lot less. So Williams and Wastel may, taking into account the new guidance, have been differently decided had that been available. And talking about diminution in value, there's an interesting point, which is, what is the actual cause of the diminution in value? And I know we've talked about this quite a lot, because we've got, well, is the cause of the diminution in value the fact that knotweed has crept over the boundary, which is the Williams and Wastel benchmark, or is it simply because there's been a long historic presence of years, and by years it's often decades, in the local area, and that is effectively what's caused a reduction in value, because estate agents and lenders in recent years have been saying, oh no, 7 metres, that's really bad news. And if the diminution in value was caused by that effect long before encroachment, then diminution in value doesn't really belong in the claim because it doesn't relate to the encroachment itself.
Yeah, I mean, if you look back at the history of Japanese knotweed, I mean, Japanese knotweed was a prized ornamental garden plant in Victorian times, widely used as a screen to block out areas. So ideally, you know, it's a great screen for to block out the railways, which is why you'll probably find that there's a large amount of Japanese knotweed in the locality, but you'll find they're particularly prevalent next to railways or in houses, you know, generally. Yeah, so it's historic in nature, and all of this would predate the 2012 guidance in any way. So this would mean that the diminution in value would technically have occurred a long time prior. We've seen a lot of cases where properties have only just been purchased, and so the div element, if there is one, should have been taken into consideration there with the purchase price.
Yes, yes, indeed. And if it's already been taken into account, then there isn't really a loss in that respect. And it's interesting what you say about ornamental planting, because this comes back to our original introduction about railway land getting a really bad press for knotweed being present. But in a lot of cases, it may be that the knotweed is there because it was planted in the residential gardens, and that's how it's ended up on railway land. So it's quite a different way of looking at it. Who is the claimant and who is the defendant? So we've got a situation where whoever is the claimant and whoever is the defendant, the knowledge benchmark is that 2012 date, which was flagged up by the Court of Appeal in Williams and Wastill. But I wonder what the position is if knotweed has encroached before 2012, because if the encroachment has occurred without knowledge, then surely there isn't a claim. What do you think?
Yeah, I would agree.
Well, it's not a point that was tested, so it's one that I think we've sort of mulled over quite a lot. But knowledge is a very important element of a claim in nuisance, and it would be very interesting to test that point out and see what a court thinks of it. And it also ties in with limitation as well, because we do tend to see claims where it turns out that the experts' reports from the claimant side and the defendant side, and they seem to agree that the knotweed encroached more than 6 years ago, and 6 years is the limitation for a claim in nuisance. It's a tricky one though, because of the very nature of plants doing their own thing. And nuisance does depend on a state of affairs, and the cause of action kind of hangs around until that state of affairs is abated. So whilst the claimant might say, well, this the knotweed is still on your land, it's still encroaching onto my land, so the state of affairs continues, my limitation period hasn't expired. But then we need to look at, well, when was the damage caused, and what is the damage, and how is it quantified? Because in most residential gardens, the claimant is going to be looking at a herbicidal treatment to bring the knotweed under control. And once the encroachment has taken place, the treatment cost is going to be pretty much the same from that point or in 6 years' time, unless there's been a really big difference, you know, unless we're talking really large scale re-encroachment. So I think that it would be interesting to make a limitation challenge on that point.
Yeah, absolutely. we've seen plenty of cases where, you know, they're alleging that knotweed has been known in the area for 20 plus years. So yeah, it would be very interesting to challenge on this limitation point, and another couple of points that Williams and Wastel didn't pick up on, the origin of the knotweed, and also the fact that if it's in residential gardens, you've got the differences in the crowns, if you like. A lot of the claimants will allege that the knotweed is more established on our land because we've got bigger crowns, but that doesn't take into consideration the cultivation of the gardens and you know, them keeping the weeds, if you like, down. And yes, that's something again that we're looking at as well.
Yes, and the sort of situation where our experts can come in very useful because they know all about the behaviour of knotweed and how it will respond. Yes. And you've touched on how a resident might deal with knotweed on their land, but that also brings into question, have they done enough to mitigate their loss by having, they know they've got knotweed on their land, have they done enough to bring it under control? Have they taken reasonable steps? Because as we know, knotweed has a mind of its own, and it doesn't just move in one direction. It may possibly have encroached from railway land to residential land, but then it can go the other way. And then the claimant who's failed to mitigate the loss and bring the knotweed under control is potentially creating or allowing an unabated nuisance onto railway land, or if it's going sideways, onto their neighbour's land, and the claimant might rapidly find itself in the position of defendant.
Yeah, absolutely, and it's really useful to see Google images and maps to see how over the years the knotweed has spread. Certainly our experts are very, very good at looking at the historical spread of it and seeing, you know, they can tend to pinpoint exactly where it comes from in a lot of cases. And the ornamental planting that I mentioned earlier, that can mean that the railway land especially, can get a bit of a bad press. The assumption that Japanese knotweed always originates from the railway land. We've had many cases where they allege that the railways actually planted Japanese knotweed to shore up embankments. Well, we've done some GIS mapping of all of our land, and you know, you can see from that Japanese knotweed is found predominantly in the built-up area around homes or areas where there previously have been homes, which will all relate back to this ornamental planting going right back to Victorian times.
Yes, and the picture of what the Google photographs are showing supports much better the story of ornamental planting than the story of the railways using it to build embankments, because there are large stretches, presumably, where there isn't any knotweed.
Yeah, and you know, we've got some steep embankments that haven't got any knotweed on them because they're in very rural areas. So yes, it's certainly something that you know, we feel we can evidence that you know, it's a good pointer, just to put that bit of doubt in. And plus as well, the claimants can't seem to provide any proof or evidence that the railways have planted, and neither can we. As a railway company, we can't find any historic records either. So, you know, on the balance of probabilities, we haven't done that, and the ornamental planting is, yeah, the ornamental planting is a lot more credible.
So that the GIS mapping, does it show any other sources that might explain where knotweed has appeared in a particular area?
Yes, there are other ways. We do find knotweed, particularly around waterways, floodplains especially, and we've also got a lot of knotweed where there's fly tipping, public rights of way. All of these can cause the rhizomes to spread. So you've got the gardeners who throw it over the fence, you know, and that will spread. And if you're on a floodplain, it will wash it down. So yes, we have noticed there are some other ways that the rhizomes can be spread. But again, it is very, very limited in the rural areas.
Wow, that's fascinating. Touching on treatment, we've discussed herbicide already, and the reassuring effect in the new RICS draft that for most areas, particularly residential gardens where there won't be large-scale development or deep digging going on, that herbicide is perfectly acceptable way of bringing knotweed under control. It doesn't then stop the resident from enjoying their garden. You could put up a shed or a summer house, anything without deep foundations that might upset the dormant knotweed roots will be fine. Excavation does have its place, shall we say, in land that needs to be developed or has been earmarked for development. Is that right?
Yes, yeah, it does. The majority of claims that we see will ask for excavation. However, excavation does bring its own challenges. Unless it completely removes all of the rhizomes, it can actually have the effect of stimulating some of the dormant roots back to life. So yeah, there's occasions where it's appropriate, and like you say, where there's heavy building works carrying out, then yes, so long as it's done correctly, then it would be fine. But herbicide is absolutely fine for the majority of residential properties and the majority of claims that we see. Yes,
and that's good because it's also a much less expensive alternative to excavation. So again, that's something that affects the value of the sort of claims that you might be seeing.
Yeah.
Okay. Well, I think we've managed to cover quite a lot in such a short amount of time, but it's been an interesting discussion, and I hope it's useful to anyone who might be watching or listening. And if they would like any further information or to get involved with the discussion, then please do get in touch with me. Thank you for spending the time today.
Thank you. Thank you.
Okay.